A good afternoon to all of you, and thank you for joining us today. I know there's been a lot of complaints. There's been a lot of Karen Reed withdrawal. I understand that. There's a lot of complaints. People don't know what to do with themselves. They're just walking around their rooms, not sure what to do. They switch around the channels and then they look in the fridge. So there's just been a lot of withdrawal. And I'm hopefully we'll be able to help you out with that today because we're getting together with Mark Bederow, who I've gone on one show with, and that was before the trial. So 20 days have passed, and we have not spoken about the trial. We tweeted out a little bit. There was one issue that we were going back and forth on. Maybe we'll bring that up. But there's obviously a lot to discuss. We don't have the whole entire day for him. I'd like to open it up for questions as well. So I'm asking you, because we can't do the super chats, there's going to be no super chats. Maybe I'll even put a banner in. Actually, no, not that one. Just to make it very clear that there's going to be no super chats. So since I'm not going to be able to tell by the super chat, so just make it very clear that what your question is and that you're asking a question. So maybe, some big question marks before that, because there's going to be a lot of people in the chat. A lot of people want to ask some questions. Start putting them in now, I guess. We're not going to start off the show with those questions. I have a few things I want to talk to him about. And then, but I do want to take some questions from the chat, obviously, also. But it's just going to be hard for me because we don't have the super chats. So just make it as clear as possible that you're asking a question. Okay, now I do want to point out one thing, which is from Catland. I received my limited edition Wisniewski t-shirt yesterday. I am sure will be a collector's item at some point. That was a limited edition. It is no longer for sale, which is why when we put something up for sale, you got to grab it before it goes out of stock or not available. So we did have those Wisniewski t-shirts, but they are no longer available for sale. So a handful of lucky people have those t-shirts. They'll be able to wear them at their next events, and everyone else is just going to be jealous. So I'm glad that you received yours, Catland. All right. So without any further ado, let's bring on my brother grifter, Mark Bederow, who I'm very excited to talk about the past 20 days of trial with. We'll pick out some of the items. So here we go. Welcome, Mark, to Brother Counsel, Brother Grifter.
How are you? I thought you were Miss Hanley, but that little accident there.
Yeah, I know. That was actually because somebody asked me in the chat as we were live streaming this trial if I can put up who's testifying. And obviously, Christina Hanley was the last person testifying. So I did get a little comment, because you know how much we're grifting here, and we're the brother grifters now. Somebody put out a great comment that said that we are the grift that keeps on grifting.
Happy to help.
Yeah. Some of the sarcasm and the wittiness that this trial has brought out in people is just amazing.
It's brought out the worst in a lot of people, and it's really a reflection on society, maybe. I don't know. But people obsessed with their keyboards over a criminal case that it's interesting, but for a lot of people, it doesn't affect your day-to-day life. As interesting as it is, as fascinating as criminal justice is and alleged corruption, it's probably not worth screaming on Twitter all day, though, and attacking people. It's not healthy. But here we are to help people yell at each other. So,
yeah, exactly. So, we've all gotten it, as you said, as we can expect, as we're covering the case. It's almost over, I would imagine. But I want to first talk to you about something that I've been thinking about. I know I've been discussing it about, and it goes right into the t-shirt, which we actually featured on this channel. And that has to do with Dr. Scorty Bello. And she testified that the secondary cause in this case was hypothermia. And we saw some back and forth with Robert Alessi trying to argue about whether hypothermia was any sort of cause. Forget about primary cause. Everybody agrees it's not a primary cause, but even as a secondary cause. And that's where he's talked about the Wisniewski spots. And the Wisniewski spots, generally speaking, which he showed, and again, we were not able to see this because we're not in court and they didn't let us see it. This were one of the jurors I think got sick that day, where they were showing John O'Keefe's stomach. And what Dr. Scorty Bello said was that there was only 10 to 15% of his stomach which had Wisniewski scars or spotting. So part of what Robert Alessi is trying to establish that generally speaking, you see at least 50% of the stomach that has Wisniewski spots. But what was not clear to me was that is that only when you have 50% of the stomach, that's when it's a primary cause for hypothermia, is the primary cause of death, or can even 10 to 15% of the stomach that has Wisniewski spots, can that still be considered a secondary cause? So what was your takeaway from that?
I don't know. I mean, frankly, to me, that was not that interesting, only because, if hypothermia was a cause or not, that doesn't speak to natural or unnatural or homicide or non-homicide. And to be honest with you, in watching the testimony of that witness, I mean, I think we're burying the lead. She basically could not differentiate between homicide or accident. And once you hear that, I mean, we heard it the first time, but you hear it in the context of the second trial, and you hear her say, it's not really what I would expect with car accidents that I'm familiar with and whatnot. I mean, I'm almost half mentally checked out, saying, I've never seen anything like this. How are we even here? How are we proving murder or manslaughter when we're not even establishing to any degree of scientific certainty that the death was caused by another human being, which is the definition of homicide, one person causing the death of another. The fact in terms of whether it had to be 50% or 10%, and, could the Wisniewski spots have been caused by alcohol and whatnot. There's a lot of evidence that you heard that John O'Keefe, for better or for worse, alcohol appeared to be, big part of his life. That's not said in a disrespectful way. That's just what some of the evidence revealed. I mean, there were even messages where he had been talking about in the middle of the day saying, I'm still drunk from last night. And in some of those text messages, he, was drunk from the bars, this and that. So to me, Scorty Bello, the bigger issue is, one could argue that she alone is reasonable doubt. And that has nothing to do, even in my view, with hypothermia. I mean, if the medical examiner can't tell you that, I don't know if this wasn't an accident. I don't know if he just got drunk, slipped and fell and banged his head, which, by the way, was kind of bolstered inadvertently by the neurologist when, Hank Brennan, I think, tried to get cute and clever with his background in Minnesota, which led him to say, oh, yeah, I've seen injuries like this. We have all these drunk people who slip and fall and bang their head, that's not good evidence for the prosecution. So, the Wisniewski spots, to me, I was not that hyper-focused on that. The defense is going to call an expert who's going to say the lack of frostbite was a significant event, which would show that hypothermia is not a cause of death. So, the back and forth, getting into the medical weeds, strikes me as kind of a secondary issue. And if there was no frostbite, and there should have been, that arguably is going to support the defense too, and that perhaps that John O'Keefe was not lying out there for the full time that the prosecution's alleging, which would have been 6 hours thereabouts.
Right, which is also which coming straight off to the clips that they were playing with Karen Reed, where she said in one of those interviews that she thought that he died at 12:25, 12:30. So let's just come full circle with that.
The clips, I mean, look, the problem with the clips, which are not, I mean, look, she shouldn't have done it. We know that. I don't think anyone is seriously going to say that was a good idea. And they're being used against her to some effect. I don't think to that great effect, and I don't think it's going to get her convicted, but it's not helpful. But one of the problems with the clips from the prosecution side is there's no context, and it's obvious. I mean, the clips are playing mid-sentence for 17 seconds, whatever it is, and she says, whatever the exact language was, that he was killed around 12 or 12:30. We don't know the context of that. That's been in the public record and the allegation for the prosecution the whole time. It doesn't strike me as that damning an admission for her to say that in light of what's out there. And I think that's kind of a leap for the prosecution to say with a straight face that given what she said in that 30-second or 20-second clip, somehow, aha, we got her. She knew that he had to be dead then. I don't see it that way. Some of the other clips, she says I was drinking, that's not helpful, but there's plenty of evidence that she was drinking. So I'm not sure it's that harmful either. But that one clip is very lacking context, but it's not good, but I don't think it's that bad.
And so, and I've been asked this question a bunch of times because I'm just taking the conversation as it goes, even though I got some other things to talk about. But I've been asked this question, and I'm wondering about myself. The rule of completeness, right? So you can't just play clips from the prosecution out of context. And I don't know how the defense is arguing with this. I don't know if the defense plans on playing their own clips, but to me, it would seem that if the defense wants to put more context into those clips, then they should be required, the prosecution should be required to play the entirety of the substance of what she's talking about, which would put everything into context. So I don't know what's going on in the sidebars, if this is going on, behind the scenes that we can't see, but where is the rule of completeness coming in over here, and how is the defense going to use that, or are they going to use it? What's going on with that?
Part of the problem is we have no clue because everything is done quietly at the bench, which is, not normal for the way usually this is done. So what were the discussions about this? I mean, it seems obvious, I'm assuming to some extent, that they stipulated to these clips coming in without a witness. So, but did that include the right to, if they choose to put them in context, they would have to be granted that right if they are in fact out of context. They may not care. I don't think she's not going to testify to put it in context. I think that would be silly. So, are they taking the approach that let him play these? They don't really do anything. Perhaps. Are they going to try to complete the clips on their own case? I don't know. It would seem logically to me that you would kind of duke that out in advance and just agree that the whole clip, whatever it is, be played at once, but that's clearly not happening. So, I mean, I'm as clueless as you are. I don't know what they're agreeing to or why it's being done, or if they're just going to let it go. I don't know.
Right. I mean, this is just one of those mysteries in the case because we all know the rule of completeness, and I don't know what the strategy here. Like you said, I don't know what the strategy is. They definitely have a right. And I would think when the prosecutor is playing these clips, you can't just say, well, you play the clips that you want in your case. No, because you're playing them out of context for the jury the first time. So
I totally agree. I also think, he's playing too many clips. I mean, he's kind of smothering. I mean, to the extent that some of these help him or he deems are more important than others, it probably would help to have picked, I don't know, 3 to 5 of the best ones and just not play clips after every witness. I mean, if the pattern of the trial is call witness gets severely damaged on cross-examination, and then I'm going to rehabilitate them with a 6-second clip, which I think rehabilitates 1 point, that's a losing strategy. A better strategy would be to better prepare the witnesses, have a better case, and not rely on proof by clips. Because the interesting thing is, so far, in my view, their strongest evidence, and this is speaking in relativity because I don't think it's that strong, but the clips appear to be, to me, the strongest evidence we've seen so far.
Yeah, I agree. And I think that there was one discussion which I caught right before they went to a sidebar where they were talking about clips, and Brennan tried to make some sort of argument that they shouldn't be allowed to play the clips in their case in chief, and then it kind of just went to sidebar. So I don't know what was going on. I know the rule of completeness, so I'm not exactly sure, but I'm not what the argument's going to be that.
Yeah, they may let it go. I mean, look, again, nobody knows exactly what they're doing or what they plan to do in their case exactly, but they may just take the view that these are out of context, don't prove anything. For example, a lot of the clips have been to establish her level of drinking, but the evidence of that is just beyond it. They've got videos of her drinking. They've got their extrapolated test. If you buy into that, there's also a lot of evidence that she was driving safely, which is perhaps a problem for them. But I mean, nothing that I've seen in any of these clips has been, oh my God, that's it. Like, that's powerful proof, as much as just kind of, going along with their general theory, but there's got to be something better. I mean, there's no homicide proven. There's no, the
Right.
experts from last week were, pretty rough sledding for them, which I'm sure we'll get into. And, they're ending their case, so we're told, with one more witness who's coming from an already injured employer, and his credibility is, to some extent damaged before he ever steps foot in the courtroom. And then they're going to rest. And you sit there and you say, how are they getting a conviction out of this?
Yeah. Okay. Well, you're jumping to a few different things, which I'm going to get into, but now that we're on the subject of the clips, I'm going to jump to that for a second because, the fact that she said one of her clips was that she said that she remembers entering the home at 12:41, which would obviously help the prosecution's timeline because it would give her more time from the 12:32 impact, which they're alleging, to get home, even though she connected to the Wi-Fi 12:36. That's undisputed. So is this something where you just tell the jury, look, I mean, the data doesn't lie. I mean, the Wi-Fi is going to connect to her phone. That's not going to lie. So
That's my point, which is, you hear the clip on the one hand about, oh, it was 12:41, and you say, okay, I guess that helps Burgess and whatnot. But then you go back and you scratch your head and you say, but if she's connecting to the Wi-Fi at 12:36 and they've tried to move their timeline 30 seconds into the future for, a critical point about the time of the so-called accident and John O'Keefe using his phone, they're making that plausibility time of her to get from Brian Albert's house to John O'Keefe's house less. And the fact that she says I went in at 12:41, the Wi-Fi speaks for itself. I mean, she's
exactly.
there at 12:36. And so now the question is, did she get home in approximately 3.5 minutes? That's hard to believe. I mean, now again, I'm not measuring the time like people are doing, but it just doesn't make a lot of sense. It is the elements that does make it harder. Then you say, well, so she's there for 5 minutes before she goes in the house. And I guess my answer is, so what? She's sitting in the car doing whatever. I mean, what is she doing? We don't know. She's not going to testify, so you're still not going to know. I'm not sure how that's proving anyone committed a crime.
Right. Right. So just finishing up the discussion about the hypothermia, because as I'm trying to figure out myself, does it really make a difference whether a secondary cause was hypothermia? Why were they fighting so much about it? Because even according to the defense's expert, which is presumably going to say that he died very quickly from the blunt impact to the back of his head, so that could have happened whether he was outside, whether he was inside. So he would have died from that. Doesn't matter where he was. So who cares about the hypothermia so much? Does it really change the defense's case to be able to argue that, Dr. Scardi-Bello got this wrong, that the hypothermia is a secondary cause? Does it really make a difference for one way or the other is what I'm wondering. And why do they fight so much about it?
I would assume the defense would fight about it because their theory, and again, I don't know how deep they would get into this, they kind of overplayed this. I think most people agree at the first trial about, proving who did what, where, when, how. But I believe part of their theory is that he was indoors, be it a house, the garage, wherever. And I think it does matter a little bit more to them because that could also explain the temperature of the phone, how it slowed down, the rate of cooling slowed down, which you saw with Whiffen. So I don't think it's the biggest point in the world, but I think they do want to establish that he wasn't out there right away at 12:30 because he went in the house. That's their position, that he must have gone in the house. So I think it has more value to the defense than it does the prosecution. But again, it not that much because the medical examiner said, I can't tell you this is a homicide and I don't see a car accident. I'm paraphrasing, obviously. And these injuries could have been caused by anything like this. Again, you can't ignore the neurologist saying you're drunk, you fall, and something else that came out of the neurologist that the jury may not even be fully tuned in, but by summation will, which is some of those facial injuries could not have happened from banging his head. And so the question is, well, how the hell did that happen? Unless the defense theory to some extent is correct. Something happened, like beyond that. So to me, I don't see where the prosecution's going on many levels.
And again, Mark, I like to play devil's advocate, and that I think it helps make everybody understand a little bit the points better. So I'm going to do that. So let's just talk about the medical examiner for a minute. So we did hear that she tries to get a report out, a death certificate, within 90 days, right? So she's not a police that can investigate a case for 3 years and then make a determination on homicide or not. She's trying to get it out in 90 days, and she's not 100% sure. So she just leaves it as undetermined, and then let the investigation play out, and then you get all these accident reconstructionists, you get Welcher, you get Burgess, you get Whiffen, you get all these people to start putting the pieces together. Then the Commonwealth can say, okay, she wasn't sure because she only had 90 days, but now that we did this full investigation, I know that there's problems with it. But just in terms of that argument that, well, if the medical examiner can't figure it out, then you shouldn't be able to figure it out 3 years later. Well, maybe no. Maybe now you could figure it out because we got all this more data that helps answer the questions.
Well, I think the problem with that is Brennan's redirect of the ME, and as he's been wont to do throughout this case, he does a lot more damage with his redirects than he does recovering any damage that had been done to him. So when you saw that exchange with the medical examiner about, were you aware of all of these facts? I hit him, taillight pieces. And she said, I was aware, and her opinion remains the same. I mean, for all intents and purposes, that answers the question that you've raised. And that was just foolish redirect. And, I mean, on the one hand, he's trying to sum up, if you will, through the medical examiner, but it took 30 seconds on recross to say, yeah, that's great. Nothing changed. And I think that was devastating to the prosecution case.
Yeah, I think it was devastating. The fact that, remember, one of their main arguments here is that Karen Reed confessed or admitted that she hit him, and Dr. Scardi-Bello knew that. She knew that she said, and still she felt that it was undetermined. So how can the jury be any smarter than Dr. Scardi-Bello if that's what you're going to hang your hat on, that she admitted or confessed, and still we don't know if this is homicide?
That's the problem that the prosecution has. You can take her admissions, if that's what we're calling them. I mean, legally, of course they are, because it's a statement by her. Yeah. But hard science trumps the state of mind and belief of a defendant who is running around like a lunatic. On the video, you see it, whether you believe it's sincere or not. I mean, I could say that, I shot John F. Kennedy. If anybody wants to believe that, they can. But, that's not what the real evidence in the real world shows. So if you have a medical examiner who's saying, that's not what I see here, you're going to have the ARCA guys who are going to say, that's not what I see here. You're going to have the defense medical examiner who's going to say, that's not what I see here. You have witnesses for the prosecution that have been discredited about the timeline when they said this was going to happen. The bottom line is, who cares what Karen Reed thought, whether it was because of her emotional state or not? That's never going to trump, in a case where the prosecution has the burden of proof, the hard science. And the reality is, their own medical examiner said, I don't see it.
Right. Exactly. Yeah, exactly. I mean, that's the problem. So moving on, let's move on to Michael Proctor, because what I've been hearing, and this is what the reports and people have been asking me from the beginning of the trial or even before the trial, is the prosecution going to call Michael Proctor? And my position has been always from the beginning that if you want to lose your case very easily, don't call Michael Proctor as a prosecution, as the Commonwealth. I think it's such a colossal mistake to not call the lead investigator, as much as you don't want to. And as much as he's going to get up there and read these text messages, and as much as he's tarnished this case, if you don't call him, you're giving this in a bow to Alan Jackson, whether he calls him or not. If he doesn't call him, then he can say to the jury, the same way he did in his opening statement, it was by design that they're trying to distance himself from Michael Proctor. And it's by design that everyone's trying to stay away from saying that he's the lead investigator in this case. And nevertheless, we saw from clear testimony that he was the lead investigator in this case, as much as they're trying to distance themselves from him. And then they don't even call him in their case in chief, the lead investigator who's trying to put away Karen Reed for life in prison. This is the person that you're supposed to trust this investigation. So I can't understand if there's any sort of reason for Hank Brennan to not call Michael Proctor if he wants to win this case. And if I'm so go ahead. So tell me about your thoughts about this, because the reports are that Welcher's the next witness and then they're resting.
So by not calling Proctor, Brennan screwed the pooch on this big time. I mean, his strategy of not calling Proctor, not mentioning Proctor, and basically, you know, what I call, because I like Orwell, just putting him down the memory hole. Like there was no Michael Proctor in the eyes of Brennan, was such a catastrophic miscalculation for a lot of reasons, but it also it destroyed Brennan's credibility with the jury, which again, as a former prosecutor, and you know, you need to connect with these people, and this is already a tough case because there are allegations of corruption and all this. And what a strong prosecutor would do is gain trust with the jury, look at them and say, I'm going to put it all out there. We got problems. I mean, I would have crapped all as a prosecutor. I would have called them, and in my opening statement, I would have crapped all over him and said, this guy is disgusting. He's a disgrace, but I'm going to explain to you why this doesn't matter. I'm going to hold your hand and walk you through this. Come with me. I can show you how to get to a conviction. But the way Brennan operates is, let's just pretend he doesn't exist. So that's bad enough. The first problem he has is he opens the door to the opening statement of Jackson, where he can just talk about Proctor as a metastasizing cancer and say, well, why didn't that guy tell me? Fine. So one of the worst parts, if you make the decision not to call Proctor, which clearly they're not, then might you have perhaps, I don't know, prepped Buchanan a little better? Because if you're not going to call Proctor, the next thing what a sensible prosecutor would do would be to sit down with Buchanan and say, listen, I know you like him. I know it's embarrassing, but like, let's be clear. We're not here to protect him, and let it fly. Okay. So let's not pretend he wasn't the lead investigator and parse words and drag out probably 3 extra hours of cross-examination, because Buchanan won't.
You mean 3 extra days?
Right. He won't admit the obvious. And then you're going to get dog walked with all of this, every search warrant, everything. And so in the process, what Brennan does, he shows that he's not being honest with the jury. He's trying to hide them from important evidence. But at the same time, he then takes the cop that he needs to be credible, Buchanan, and demonstrates that he's not credible because he's clearly lying about Proctor. And it's like trying to pull teeth from him, such to the point when you get to some of those text messages that you saw, and they've got thumbs up, literally thumbs up emojis. He's saying, well, that's just me acknowledging that he didn't, the text message, not, hey, no nudes yet. Good work. That's just ridiculous. So the problem with all of that then is, so Brennan has showed the jury that I'm going to hide evidence from you. I'm not going to address the problems in my case. And that goes on, and then it gets worse. And I don't want to jump around, but the point remains the same. Then you get to Burgess. We don't have to get into him in detail right now, but this point goes with the prior point. You call this guy, and what do? You establish every credential he has as an expert except one, his academic record, clearly indicating to the jury, I'm aware of it, but I don't want you to know, as if he thinks there's a 1 in a million chance the defense isn't going to bring it up. And then they do, and they mention to the jury, why am I bringing this up on cross as opposed to Brennan, who then does it again on redirect, which was really stupid. And it comes out again. But now the jury is, if they weren't aware before, they know that what he did with Proctor, what he did with Buchanan, what he did with Burgess, he's not calling anybody with the last name Albert. The only impression you're leaving is, I don't want you guys to know things. And so he's yielded in what I would call the righteous indignation. He's yielded the white hat to the defense, which should never happen when you're the prosecutor. So now the defense calls Proctor, and the jury says, they're going to tell me. They're going to tell me. And in summation, I mean, what do you think Alan's going to say? Why are we doing this? And not only that, the long...
You know what he's going to say? He's going to tell the jury, you know why we call Proctor? Because we care about the truth.
That's
We
right.
want you to know the truth, and they don't want you to know the truth.
That's what I mean by shifting the white hat to the defense. They've stolen the moral authority to be the good guy, which is supposed to be the prosecution. And not only that, you go on a 6-day break or whatever it is, which in the middle of a murder trial is like, never mind it's Memorial Day. That's a long break. But they end with the strongest evidence yet that Proctor probably planted some glass. There's no real explanation for that. And that's what's festering in their mind. And so to answer your question, what feels like 30 minutes later, Brennan not calling Proctor, the real damage he did was to his own credibility with the jury. And he yielded the moral authority as, I'm going to give you the truth and lead you to a conviction. And he made the defense the good guys in this case. And that's stunning that he would do that. He's been a prosecutor. He's been a defense attorney. This is not rocket science. And all he had to do was call Proctor and tell him, when you're up there, I mean, if you're prepping a guy like Proctor, you would say, I mean, we've had these conversations on cross-examination, don't look at me. You're going to take your medicine like a big boy. I'm not even going to object. I'm going to let them chew you up. You know, that's the mistake Lally made at the first trial. He tried to like stop this. No, if you're going to do it, you know, and then you, in your summation, if you're Brennan, you say, it doesn't matter because we have trigger events and we have this, but he's hiding evidence. It looks terrible.
Yeah, and this is a pattern that we keep seeing in the case. I keep telling everybody about it, that you can't do this, you know, especially when you have a defense team. You know, you got a rookie defense attorney, okay, but you got a defense team like this. They're not going to let you live it down, and they're going to jump all over it. And I don't understand the strategy. You know, it's just you got to own the mistakes, you got to own the weaknesses of your case, and you can't just run away from them. And what we're seeing is what happens when you try to run away from them. You know, you get looked. Yeah, exactly. So, okay. I mean, if he doesn't call Proctor, then you know, that in itself, if you had nothing else in this case but the fact that they're not calling the lead investigator in this case, that itself could be an argument that you're obviously not getting the full story, and that means that there's some doubt in your minds and their minds, quite frankly, and that's why even that by itself, they can, I think, is a strong argument to lose the case.
The defense argument here, you know, at its core, at its base level, is that the police, in particular the state police, got real cute early and decided she was going for this and helped it along, if you know what I mean. They you know, just to make sure, helped it along by doing certain things. And what feeds into that narrative more than the disgraced, terminated former lead investigator who was terminated for actual bias in this case doesn't even exist and is not the lead investigator according to the prosecution. I mean, the irony is Brennan likes to accuse everybody of consciousness of guilt. That is consciousness of prosecutorial guilt.
There you go. Got it. Let's go into the glass pieces because you mentioned that about the glass pieces on the bumper. So we know that from Christina Hanley's chart, and thank God for Alan Jackson, because we spent 3 hours hearing about 7-14, 7-12, and nobody knew what in the world she was talking about. So I remember this motion that was filed before where they're asking, can we just please have a chalk, Judge Cannoni, so that everybody can understand what's going on? So they had to establish that with the jury, with Christina, as you saw, laying the foundation, making sure that the chart is accurate. Then they put the chart up there. It's like, oh, what, we wasted 3 hours and now we see this chart. But at the end of the day, the chart showed that there was all the pieces on the bumper did not match the glass, right? And I've heard, because, you know, we got to be devil's advocate here. So I've heard that some people are saying, well, you know, it wasn't a physical match. It doesn't mean that it didn't come from the glass. It's just that she cannot positively identify the similar characteristics between this glass and the drinking glass, and really maybe it does fit together, but they're just so small, or there's other reasons why she couldn't make any sort of physical match. So what's your response to that? I have a thought, but I want to hear what you have to say about that.
It's a very simple response. I mean, that sounds like, you know, a lot of the Twitter people who get together and they're going to push a narrative. People need to understand, like the lawyers do and people who follow this, there's a burden of proof, okay? And if the prosecution side is the one trying to justify why the glass doesn't match, and it could be this and it could be that, when you're the one flailing around and speculating and have the burden of proof, and we're talking about Michael Proctor, who the jury knows doesn't exist according to the prosecution, has been terminated for misconduct and bias in this case, you don't get the benefit of the doubt. You don't get the speculative benefit. So the bottom line is the arguments that you're parroting, not you making them, but you're sharing that people are making, if that's the prosecution, they're coming from a position of weakness, not strength. The bottom line is this: when you factor in the burden of proof, Michael Proctor is a disgrace. I mean, that's not me. The state police said, get out of here. You're terminated.
Dishonorably discharged.
Because of this case, like your conduct here, that's bad enough. So now you realize that they find all this evidence, and when they take the car into the Canton police and finally are going to take pictures and look at it, we have a busted out taillight, which, you know, there's all kinds of allegations and evidence about that. But there's, you know, pieces of glass conveniently located right around the right taillight, sprinkled around. And you say, your first instinct is to say, well, wow, that's got to be the glass John O'Keefe was holding. That makes, you know, that seems to be evidence that how did that get there unless he got nailed and it shattered? Okay, fine. So it turns out, as you said, that the glass was not a physical match, whatever. Well, what about the other match? That's the prosecution's problem. Do the work and give me the proof. So again, the evidence that we have right now is that it didn't physically match. Well, didn't physically match what? Other glass that was found by Michael Proctor, how convenient, weeks later, right around where this incident happened. So how in the hell is the prosecution going to explain that there was glass sprinkled about over under the right taillight, that Michael Proctor also found the same consistency outside the street where the accident allegedly happened? The only person who ever touched that glass was Michael Proctor. And wouldn't you know it, it's random, or appears to be anyway, random glass that has nothing to do, as far as we can tell, with this case. And so you can go through your mind and say, what is the most logical explanation for that? And if you're a juror, you say, well, I know Proctor is dirty in some sense. I know that he's, you know, disgraced. I know that he's terminated. I know that they're not calling him. I know that they're lying to me about his role in the case. And wouldn't you know it, he's the guy who's linked to glass that doesn't match anything, that appears to show that John O'Keefe's glass, you know, the suggestion was on the bumper. And you factor that in with everything else and the allegations against him, the taillight, the not taking pictures. And you say, what's the most logical explanation? Doesn't mean it's true, but the most reasonable explanation at this point is, my God, he really did plant evidence.
Yeah, you know what else? Maybe that glass, maybe there was a broken glass inside 34 Fairview, but they never recovered it because the house was never searched. Maybe that glass outside would have matched that glass.
Maybe. I mean, but again, you're now speculating from a pro defense side in the argument you're making, which is more normal and what you would see. But the people that are criticizing, you can't draw these ominous conclusions about the glass on the bumper. You absolutely can, because it was the prosecution's job to show you whether it was or it wasn't. Why didn't they scientifically evaluate it deeper? Did they not want to know? I don't know. Once she said by physical review, it's not the same glass, was she told, like, kill it, we don't want to make it worse? I mean, I don't think we heard an explanation for, well, why didn't you look at it and compare it?
Yeah, and what I was thinking, you can tell me what you think about this, is that, remember the debris that you found in the t-shirt and the sweatshirt, right? So they were tiny, they were minute, like 16th of an inch by 16th of an inch, and she was able to look at that under a microscope and say that it's a physical match with the taillight.
Right.
And those pieces of glass were bigger than a 16th of an inch by a 16th of an inch, right? So if she's able to do that with these minute, tiny pieces of plastic, you would think that she'd be able to do that with the glass, and still she's saying that they're not a match. So if they're not a match, then, and you see that she could make matches even on tiny, tiny pieces, yeah, I think that argument falls absolutely flat on its face.
I agree. And I also think, for whatever reason, I remember her from the first trial, but I don't remember it that closely. But I don't remember her at the first trial being this terrified. She struck me as extraordinary. By the way, totally truthful, credible. I have no doubt she seems like a very nice, honest. Just because she works for the state police doesn't make her corrupt, anything like that. But she looked extraordinarily, and that also I don't think is a good look for the prosecution. I don't want to read
Mark,
too
can you
much
just say that one more time because you just froze when you said extraordinarily something?
I said she looked extraordinarily uncomfortable.
Oh, comfortable.
Okay. And I don't know why. And I don't want to make the biggest deal out of the world. It is what it is. But she looked like, she was testifying, while being held hostage. And she looked terrified of what she might be asked on cross-examination. And she's just a scientist who's, seems like a nice person, professional. And I think it's a bad look for the prosecution as to why you're a credible scientist who, at the end of the day, gave evidence that would, could have been very harmful for your case, meaning the prosecution was so uncomfortable by appearance. And I just don't remember her being like that the first time, although I could be wrong.
Right. Let's move on a little bit more to the plastic that we're talking about, the plastic that was recovered. So let's talk about the pieces of plastic that were recovered by the CERT team, because I know that this is, and I like to play devil's advocate here. I know that this is a favorite of the people that want Karen Read to be convicted, that the pieces of plastic that were recovered by the CERT team was before Michael Proctor had any sort of chance to plant those pieces. So at least those 6 or 7 pieces of plastic, how did they end up there if Michael Proctor didn't plant it and didn't have the opportunity, unless you say that Kevin O'Hare is also as part of the conspiracy? What's the explanation there?
I don't think that's accurate, in the sense that the team started at around 5:45, whatever the exact time was, and you have to break down. You have like 2 timelines happening at the same time, and the CERT team starts around 5:45.
Well, they said that they said they said they started around 5:24. They recovered the first piece. Right. They recovered the first piece at 5:45.
Yeah. Which is not what he said at the first trial, by the way. And I'm not sure, that probably should have come out, but whatever. But whatever time they started, you have to look at the testimony of the search coordinates very carefully. They're basically saying we're going to start on the street, moving towards the fire hydrant, if you can picture it in your head, but they're starting equal distance or equidistant to the door of the house. And then the flagpole and the fire hydrant are several, 30, 40, 50 feet down the street. And they're doing this in a blizzard, deep snow, some of that snow deeply compacted from plowing and, hard snow, all that stuff. And they say they're doing this slowly and methodically. We're digging and sifting. And the impression you get is they're moving really slowly because they don't want to miss anything. And let's even use the timeline of 5:24. That would mean that they found in 20 minutes, in those conditions, with feet-high snowbanks and all of that, going slow by slow, a needle in a haystack, a couple pieces of glass by the flagpole equivalent of the street in 20 minutes. Now, why did they say at this trial that they started at 5:24? And why do I think defense missed an opportunity here? Because there's a really disturbing pattern in this trial of evolving timelines. Okay. Yeah. In the first trial, it was 12:45, and that comes from Jen McCabe, but we can't have that because the trigger event. So they move that. Then you find out Whiffin's timeline with John O'Keefe's phone and the variant. We got to move it again. The timelines are always moving here. Now you go to the other side of this conversation. You said you have to watch 2 timelines. You know that Proctor lied under oath repeatedly about the time they found the car. I mean, he just lied in his search warrant affidavit. It's no scrivener's error. It's a lie. Let's call it what it is. But you also know from the video that these guys were at the Canton garage around 5:35.
Right. Okay? That's when the car got there.
Okay. So that's 10 minutes before, even by these guys' claim, they found the glass. It doesn't take 10 minutes to get there. Now, that doesn't mean Michael Proctor went racing over. It doesn't mean any of that. But the question is, how does it get there, and who finds it, and how do we know what we're being told is true? So now you go back to the search, okay? And here you have to enter another cop that they just mysteriously don't want to call. A guy named Tully. You ever heard of him? He is the quarterback of this whole operation for searching. And number one, he doesn't use the crime scene unit, which is the appropriate arm of the state police to use. They are the ones who search, photograph, document, and voucher evidence. He uses a team that's more like missing persons type of thing. They don't document their own evidence. They don't photograph their own evidence. They're not crime scene guys who are going to be obsessed with making accurate records of everything. That's what they do. So by using the other team, that means that Tully now is playing an important role in the search because he's the one documenting everything along with O'Hara, who normally would be searching. Okay. So then you find out when they're searching outside the house, the CERT team, there's this mystery squad of 5 men who don't belong to the CERT team. And they're not all identified. We don't know who they are. He says, I think some of them came from the state police, but I don't know. And then you run into the next problem with a CERT team as opposed to a organized crime scene unit team. One thing you're missing from Tully is there's no documentation of this piece was discovered by officer so-and-so. It was then recovered by officer so-and-so. That just doesn't exist. It's just, we found it, but you're sitting here, you don't know who found what. You don't even know if it was a member of the CERT team or one of these mystery 5. Now, there's other things you have to factor in, such as Tully gets there, talks to O'Hara. O'Hara asks him, you have a picture? What am I looking for? Show me the taillight, like what it looks like. And what am I looking for? And Tully says, we don't have a picture. Now, at the time that conversation happens, his guys, Buchanan and Proctor, have had the vehicle for a long time. Okay. Common sense would have said, remember, these guys claim they never took a picture of the taillight, which is crazy. Right then and there, give me a picture so I can give it to this guy. Doesn't do it. Okay, fine. They then find allegedly 3, 4, 5 small pieces of taillight in the area that Gallagher already searched. And then you have to look at Gallagher. He said, I did a 7x7 search. And if you kind of graph the
hold on a second. Let me just I thought Gallagher said that he searched in the lawn, and the CERT team said they searched in the street.
To the edge of the lawn. There is, but if you go 7x7, which is what Gallagher said, you're going to get in the same area.
On the street?
So, moving onto the lawn. It may not literally cross over. What I'm saying is the same general area. Remember, there's 40 something pieces. If Gallagher, if they're over here, they can't be scattered around the lawn like it turns out being. But forget that for a minute. They find a few pieces. I mean, obviously a small amount of taillight. And then the weirdest conversation you'll ever hear in law enforcement happens. O'Hara, who I don't think anybody suggests is corrupt. He's just showing up, doing whatever he's doing. And he says, I think we've exhausted what we can do tonight. We'll come back tomorrow in the daylight. And, it's obvious we're missing a lot of pieces. And Tully says, we're good. Don't worry about it. No worries. No need to keep searching. So you factor all of that in. Okay. You factor the timeline. You factor that there were unknown people. You factor that, you see the Sally Port video. People are coming in and coming out. Could somebody have just had it over there in a couple of minutes? One of these mystery people, Kevin Albert, would he blend in nicely? I mean, that's Brian Albert's brother. They saw people lurking around the Albert house, if you remember, saying, what's going on? Are you guys here to do the search? Again, they don't have a burden of proof, but it's totally plausible. The timeline totally fits. and you look at just the testimony of finding the glass, even if they started at 524 taillight, not glass, in those conditions, in that way, factored in with what Tully said, what Proctor and Buchanan did, the 5 mystery men, and it doesn't sound so crazy that something could have happened. And then there's one last fact.
Do you mean like even under O'Hara's nose? Because he's testified that when he was searching, no one was like, coming into the scene and planting things or whatever. But you're saying that in those type of conditions with the mystery men and with Tully and the oddity that the fact that the search team is there in the first place, it's not really their expertise, that something could have happened even under his nose.
He's one man. He's not doing this. And what I found also interesting before the last point is the person or people that I would be calling on the CERT team, if this is the case you're trying as a prosecutor. O'Hara, to me, is kind of the broad stroke guy who says, okay, this is the team we assembled. Here's what we did. Why didn't Brennan call the guy who's like, I found the piece? Me. It's me. Why didn't he do that? That's weird. But the other point they have, which
probably because it wasn't documented.
Well, but again, that's a you problem, meaning the prosecutor, not a me problem, the defense. And then you have the fundamental problem that kills all of this for the prosecution. And none of this, we wouldn't be talking about any of this if they had done one simple thing: secure the crime scene. That's it. If you put cops from 6 a.m., change shifts until the CERT team arrives, and if they establish for the jury credibly that at all times we had police, and I don't mean an army of 20, one guy with a large Dunkin' Donuts sitting in his car staring and making sure no one's creeping around. If they establish that, then it would have been impossible for the evidence to have been planted, assuming that was credible testimony about a crime scene, and they didn't do it. And that's on them. That's just stupid.
That's another thing. Let me ask you this. What about the suggestion that when John O'Keefe maybe was in some sort of argument with Karen Reed, he got out of the car and, Dr. Wolf testified that, he had to build this cannon. And maybe John O'Keefe took the glass in his drunken stupor and threw it at the taillight while he was walking in. Maybe he was drunk. Maybe he actually fell down, as the neurosurgeon said, and cracked his head open. Karen Reed doesn't know what's going on with him. She can't find him all of a sudden, but she doesn't realize that he just died right there. And that would account for the 6-7 pieces of taillight. That would account for some pieces of the glass. And that would make everybody in this case as truthful as possible, and still show how some of these things happen.
Except number one, there's no evidence of that, and number two, then why?
Well, just to cut you, I'm sorry, but according to the ARCA experts, that's the most plausible explanation how this taillight got broken, right? That's why they built that cannon, to say
Sure, but then why is it Michael Proctor's planted glass, or whatever the hell we're calling it, on the bumper rather than the glass that John O'Keefe threw?
Right. Well, maybe then once they came up with their theory of the case, maybe that's when he started having to buff it up and started. So,
I know you're just playing devil's advocate as prosecutor, but you're falling into that trap. I don't mean you, obviously, because I think you're taking commendably the weaker position because we're having a conversation here. But once again, you're in the role of prosecutor and you're speculating and using the word maybe. And when you're the prosecutor, maybe equals only one thing. Maybe equals acquittal. Maybe doesn't work for the party with burden of proof. It just doesn't work. And all of these questions stacked on top of each other, all of these abnormalities, all of these other things only lead to one thing. And that is, sorry, folks, but there's reasonable doubt here.
Right. But I mean, my theory would actually, that John O'Keefe actually threw the glass and then somehow slipped on the curb or something and actually fell, like the neurosurgeon explained. And that's how he died. Nothing to do with Karen Reed. She's innocent. The people in the house are saying the truth. Proctor may be a piece of garbage who planted some evidence, but that is the theory that everyone would kind of walk away from this case as unscathed. People in the house are saying the truth. Karen Reed saying the truth. Everyone's saying the truth except Proctor's a piece of garbage. And maybe he actually planted some of this evidence to bolster the case against Karen Reed, and just he's the only nemesis or villain in this case. That's why I'm suggesting that theory.
The problem with, and again, I mean, that would obviously be an acquittal, which most people say that works for me. That's fine.
Yeah, that's what I'm saying.
The problem is, how do you get around the other oddities? And again, I'm not talking about proving who did it, but how do you get around the weird butt dials, the deleted searches, the family text message chain, which is devastating. The private text exchange between the family is a disaster for them. And that really was emphasized again by a huge mistake of Brennan on redirect, really emphasizing that point, because he, I don't want to get too off point, but he tried to suggest that Jennifer McCabe was traumatized and upset in her messages to Kerry Roberts, who at that point was somebody she's got to bring in. She's got to get her with her. But when you look at the family, and Kerry Roberts, she may be Jen McCabe's, patsy or useful, we'll bring her into the fold. She's not family. And at that point, she's nobody. She doesn't even know her, really. But the family, they're not talking about John O'Keefe. They're talking about the guy. They're not talking about grieving for his loss. They're talking about, what do the cops know? Where are they searching? And why is Kerry Roberts telling them everything? And the guy didn't go in the house, and tell them this, tell them that. That behavior is not innocent. Okay. That's not grieving. That is, we need to stay one step ahead of the constable. That's what it is. And
if she pleads, this all goes away. If she doesn't, then it's going to be a spectacle, whatever he said. Yeah.
No innocent explanation for that. It doesn't mean anybody killed anyone or anything like that, but it is a consciousness of, what do they know about us? What are they going to find out? And they're obsessed with knowing, how do we factor into what the cops know? They're not grieving. And it's Brennan who tried to portray Jen McCabe as, so upset, so shocked, when privately she was gleefully saying, Kerry's telling them everything, with like multiple exclamation points. That's another own goal by him. I mean, so that kind of behavior is just not consistent with a total accident, as is her Google searches, not the big one. She was Googling herself that morning. Okay. She's Googling herself and Googling John O'Keefe. Why? That is consistent with the family text chain, which is, am I a part of this? Are they going to name me? Am I like that? That's a strange thing to do when you're grieving about your close friend who just tragically died, on your brother-in-law's lawn.
Yeah, I mean, I think that you're absolutely right with all these questions, and the fact that they're not going to call Brian Alberts. So we're going to hear about the dog being rehomed, the house being sold. We're going to hear all about that for the first time from the defense. It's just, I can't wrap my head around. Hank Brennan seems to be like he's a trial lawyer. Seems like he knows what he's doing, and then these type of things, you're trying to hide all this evidence, which is going to come out. I mean, these attorneys. I mean, if I was a defense, I would absolutely call these, Brian Higgins or Brian. Now, I'd call them all.
I've said to other people, because this gets asked probably more than anything else, he's not calling all these witnesses. Even, a few hours ago, I told someone I would absolutely call Proctor, absolutely call Higgins, absolutely call Brian Albert. I'm calling Matt McCabe, which I'm happy to talk to you about in a minute. And I'm giving strong consideration to calling Nicole Albert, although I could be talked out of that, I think. But, some of these witnesses, like Matt McCabe is a perfect example. He's on that text chain saying some really bad things that only he can explain. Beyond that, he's the other person who claims he's looking out the window and matches his wife's testimony almost to a T. That's interesting. But the most interesting thing about him.
Also, he heard Karen Reed say on the phone, what did she say? My taillight's broken. Right. And that's why he tells Jennifer McCabe that she can't go out at 5 o'clock in the morning with a broken taillight.
Right. But he lets her go drive out in the blizzard while he stays home and goes to bed. But
I never understood that. Like, you know,
well, there's an explanation because it's probably not true. But the biggest thing about him and why I would call him is because of Burgess the other day. Now, he is wrapping his data around the 3-point turn. That's his like benchmark for the variance, and this proves everything and all of that. And they played the clip. You mean you want to use the clip against them and stick it to them for playing too many clips? They played a clip of Karen saying, and I made a 3-point turn. Nobody doubts that she made a 3-point turn. But here's what gets interesting, okay? According to Burgess, the 3-point turn was made on the side street, Cedar Crest or whatever it is. And I think the time was roughly 12:23.
yeah,
Well before Karen shows up in front of 34 Fairview. And well out of range of the Albert window that looks on a 34 Fairview. So on January 29th, as you know from Buchanan, they go down to Dighton in the afternoon and they interview Karen. And she tells them, I made a 3-point turn. She tells them that. And if you recall in the early part of the case, that's the theory that the cops go with, that how she killed him. It was during a 3-point turn. She ran him over before they decided she did it in reverse. But here's where it gets interesting. Matt McCabe tells Proctor, there's that name again, later on January 29th that, well, when I was looking out the window of 34 Fairview, I saw in the street when there was a light dusting of snow, tire tracks in a V that was a 3-point turn right in front of 34 Fairview. Okay. Now, if that were the case, there'd be a triggering event like the other one. There wasn't. Okay. So the question becomes, how in the hell did Matt McCabe come up with this blatantly false, almost certainly lie that he saw strong evidence of a 3-point turn, which he did not notice until Karen was there? I mean, he basically all but said, I saw her do it. And it just happens that the guy who wrote it down was Michael Proctor, who was the guy who earlier that night heard Karen say there was a 3-point turn. And now you have Burgess who says, actually, it was over here. So I would
and on top of that, you have Jennifer, just to fill it out. You got Jennifer McCabe looking out the window who does see tires. You got Ryan Nagel who said that there was no tire tracks, right. And he was right there on the street.
Exactly.
And
exactly. But my point is, this is not something you're using to blow up Burgess. He did a lot of that job on his own. But what you're doing is you're using Burgess the one time he appears credible against the prosecution by saying, if that was the 3-point turn, then Matt McCabe is lying. And, you know, that has to, and again, it all goes back to Proctor. And if these people on January 29th were already coming up with lies about a 3-point turn, that is absolutely devastating to the prosecution case.
Yeah, and this is, again, something that Brennan's just going to try to hide and hope that the defense doesn't call Matt McCabe and talk about this.
The other problem he has by not calling any of these witnesses in the house, other than Jen McCabe, at the first trial.
Well, he also called Julie Nagel, right?
No.
Or Sarah Levinson.
No, he doesn't want to talk about the blob anymore because I guess it's even too much for Brennan, because that would be the one you would call, really, if you're going to do it this way.
Right.
But
I'm sorry, I meant Sarah Levinson.
At the first trial, when the defense went real heavy with he had to have gone in the house and all that, the logical pushback from the DA, Lally at the time, was, I'll just call an army of witnesses who to a man and woman will basically say name, rank, serial number, and he never came in the house, and get off the stand. And he was able to say there's no evidence and there's all this compelling evidence. This time, Brennan has one witness, really. I mean, Levinson really didn't see anything anyway, looking outside, or it's only Jen McCabe. If the defense calls Higgins from the first trial said a guy came in the house, and he didn't say it was John O'Keefe, but he said he kind of looked, he had the same characteristics. But If Higgins is admitting someone came in the house and Jen McCabe says that's not true, that can only lead to two conclusions. Number one, Jen McCabe is lying, or two, and this may be even better for the defense, I don't know, maybe Higgins was in a different part of the house where Jen McCabe didn't see, like the garage, perhaps, or something like that. But Higgins is going to have to say some guy came in the house. And what Brennan doesn't have is this army of witnesses to say, I've got 15 people who said nobody came in the house. So he kind of sold himself short on that as well.
Yeah. Yeah. I mean, amazing. That's exactly sets it up right there. So, I mean, that's why I'm assuming we're going to see the defense call these witnesses. If Brennan continues with this idea not to call them.
Right.
Let me just ask you one more thing before we get to the other questions from the chat. Burgess testified, and we don't have to go through that whole debacle. We probably discussed it already at length, both of us. But the only thing is that here's the question that everyone's thinking: did Burgess really destroy any chance for Welcher to be credible to the jury because of Aperture? Aperture was listing Burgess as an expert all the way back to 2013 when they were submitting his CV in this expert case in the federal case in Texas. So Aperture's got him listed on the website. They got his credentials wrong. Aperture, at this point, probably doesn't have that much credibility with the jury. And now here's another person from Aperture, Welcher, who's going to testify and try to convince the jury. So the question is there any way that Welcher can, either by his real education and experience, be able to kind of distance himself at least from that attack on Aperture that we just heard from Burgess and be able to have any sense of credibility for the jury?
It's going to be a hell of a task because Brennan, if you're not going to give him credit for anything, give him credit for this. What he did with Burgess was a triple whammy. He ruined his own credibility with the jury, meaning Brennan. He ruined Burgess's credibility with the jury. And he's already damaged, I won't say ruined, but has damaged Welcher's credibility before the jury before he's ever stepped foot in the courtroom. So,
yeah.
At least on that task, that was a good job. Welcher comes in. He's the senior vice president of the firm as well, which raises other fascinating issues beyond his work. He may be the competent witness to talk about billing and due diligence and how we, list our credentials. He may be a proper witness to do even more damage about, sir, is your company a fraud? Like, are you deliberately misrepresenting things? I mean, he could be vulnerable to that. He also could be vulnerable on other points before you even get to his opinion. Lawyers understand, I'm not sure if the jury does because they're not lawyers, presumably, or maybe there's one or two, I don't know. Experts never act on their own. They're not rogue agents. And I'm telling you from my own experience, and you would say the same thing, and any other lawyer who's experienced would say the same thing. I don't hire an expert and get an opinion, and then they just decide on their own without telling me. I'm going to go do more experiments and then call you up in the middle of trial and say, hey, guess what? That's not true. That's impossible. But there's another interesting point here. There's something else why Burgess would never do that on his own in calling Brennan. Burgess is a low-ranking nobody at this firm, okay? He would have gone to a superior or someone else in his own firm and said, what do we do? Should I have issues. And presumably that would be Welcher because they're working on the case together, and Welcher's a doctor and, a real expert, supposedly. We'll find out, but I imagine he is. And there's no question that if they had an idea that, we think some of the defendant's data is wrong and we need to reevaluate our own, it's impossible that Welcher would not have called Brennan and said, listen, what do you want us to do? We have an issue. They would never at Aperture just do this rogue on their own. And also, they're getting paid for their time. By doing rogue work, what are you doing? You're billing extra without even telling your engaging attorney. That would never happen. beyond all that, which I think he would be subject to cross on, the problem that Welcher has is Burgess's data is a factual predicate for his own conclusions. And Burgess has, never mind the academic nonsense, he's admitted that I did it wrong the first time. And you've already seen from the examination that Welcher's report is based on the so-called wrong data. So what does that do for Welcher? And when did he first learn from Burgess? And so this becomes just a complete mess. Is he going to say, oh, yeah, I'll just move my timeline too because Burgess did? I mean, in a case like this is pathetic. I mean, how is the DA even in a position that we're talking about their most important expert, whether he's already discredited or not before he ever steps foot in the courtroom? That's crazy. I've never seen anything like this.
Yeah, maybe one of the first questions to the ARCA experts is, are there any experts that are listed on your website that actually do not have the education that they say they do?
Listen,
like it's ARCA versus Aperture right now, right? So
yeah, but I mean, you could even ask Welcher, like, are you aware whether the guy had a degree or not? And who knows what he'll say? I mean, look, they don't even work in the same office, so they may just have been connected for this case. They may not even know each other so well, but I mean, the answer to your question is, yeah. I mean, his credibility is damaged going in because his firm is humiliated and he relied on the disgraced expert's data. And it's not just, by the way, the fact that he appears to have fudged his academic credentials. He didn't know the difference between bytes and bits in the beginning. And, I may have done that too, but I'm not an expert in computer storage. That's kind of a problem for me if you're an expert. And then
that's like you mixing up the difference between a statute and case law.
Right. That's right. That's exactly. And then he also, he does this beautiful timeline, which is supposed to be compelling, and he's off a day. And that doesn't undermine the actual data. I have the wrong day, but it goes to the similar point. You're careless.
Exactly.
By the way, if you're not corrupt on your academics, then you're careless for not seeing it and not fixing it. And I'm not sure that's a good outcome either when you're supposed to be a brilliant expert. You're not attentive, you're careless, and oh, by the way, you changed your opinion on your own, which is another example of I did it wrong. So and is going to have to deal with that baggage. Absolutely.
And like what you said, the fact that, dealing with experts, no expert just does work because, maybe I got it wrong. They're going to charge you. They're going to keep track of their time. There's going to be a separate correspondence. You sent me these additional things to review. I reviewed them. This is my opinion now. And here's the bill. Like
there was correspondence per your request. And he probably
copy and paste.
But again, interesting point. You're damned if you do, you're damned if you don't. Either Brennan did in fact ask him to do it, which is probably true, or, well, it's a cut and paste. Then yet again, you can't even edit your letter that you cut and paste and take out the non-germane or non-appropriate language. Another example of the expert being careless and inattentive.
Yeah, and the fact also when you were mentioning that Brennan tried to rehabilitate him by saying, well, you don't know what happens, with the website. You're not in charge of the IT department, or you don't know how they update their website. I mean, that also is just, I think it goes against common sense. When you get your first week, when you're involved in a company, no matter how big the company is, you're giving them all the information, all of your background, all your education. They're sending you emails. Okay, does this look right? Okay, yeah, you're not the one actually going to the software.
Show me in your career. I tweeted about this the other day. Never have I seen an expert, and if somebody disagrees, show me an expert in this kind of field, meaning they testify, they're involved in litigation all the time. Everyone who's going to hire you, I need to see your CV. I need to vet your CV. I need to know, do you have all this? The idea that Burgess is claiming for the better part of years that he had no idea what his CV said. He can't explain why He apparently was pursuing a degree that, for 17 years. He can't explain why his expected graduation date is moving back and forth all the time. And perhaps most shockingly, he can't explain why the degree that he either at any given time claimed he received or was going to receive doesn't exist at that university. So if you want to throw it on Aperture, where did they get that information from? And beyond that, they're representing you. I mean, what expert who testifies in court all the time and submits their CV isn't looking to make sure it's at least up to date? I'll give you a couple months, but not 17 years.
Yeah, and I was wondering myself, because like as I was watching this trial and I was live streaming it, I was saying, I would love for the defense to, to explore. So you've been working on this degree for 17 years, right? So tell us about how much you've been working on that for the past year. How many credits did you take? How many classes did you take? And then, work backwards and so you didn't take any classes for 4 years, but you're still working on it. Like it would have just made him, but maybe they just got enough.
It's crazy because this is not in front of the jury, but this was reported last night by a really good reporter who did the work, called the school and got a comment. And it turns out that Burgess has not been enrolled in any capacity at this Alabama school since 2019. Now, 6 years, but he still claims I am currently, i.e. present tense, pursuing a degree. That's a lie. What you're doing is, I've taken courses. That's the proper testimony. Or I'm 5 credits short. He's not pursuing anything. That's just a lie. Now, the jury doesn't know that. But, if you remember last week, Brandon said, well, I may need him for rebuttal. Yeah, I think it's safe to say, Mr. Burgess, we don't need to pay for your flight back to Boston to testify in rebuttal of ARCA. I mean, I don't think that's going to happen. And if it does, I think you're going to see a whole nother round of attacking on his credentials. I mean, it's insane.
There's no way he calls it back. But I will tell you, Mark, that I am still pursuing my career as an MLB pitcher. I do every once in a while go out into the backyard and play catch with my kids. And sometimes I can really bring it up to like 30, 40 miles per hour. So I am still pursuing that.
That's excellent. And you've got, all things considered, you got another 50 years of pursuing that. So keep at it.
All right. Well, we'll do it. It's going to be on my resume from now on. Let's get to some questions here. Okay. I'm starting from the beginning, guys. So I'm sorry if I'm not going to get to your question, but we'll do the best we can. Here's from Laura. Question: why aren't the jurors being sequestered? Seems unfair to expect them to avoid anything related to the case over the holiday weekend.
I mean, you would have a hell of a time in getting a jury for this case when they start a jury selection by telling them that you're going to be up to 3 months sequestered. It's too much. The jury is asked every single day whether they talk about it. They all appear to give the right answer. You can roll your eyes, whether it's true or not. There appears to have been a hiccup in this the other day because they somehow questioned every single juror, and it appears to be about this kind of thing. Nobody got kicked off. So, was there a conversation in the jury room where somebody said, hey, did you hear this? Who knows? But sequestering, it's brutal. I mean, what are they going to do? They're going to live at the Dedham Holiday Inn for 3 months and basically have no real access to their devices except for a couple hours a day in the presence of, somebody from the court. You'd never get a jury in a case like this. You just wouldn't.
Yeah. You got to trust them. Another question. Hello Kitty. Who will be the first witness and last witness for the defense?
So I have a really outside the box view of this, but there is a method to the madness. If I'm the defense, I'm calling the ARCA guys first, not last, which most people would assume. I'm calling them first because, you've just seen Burgess and Welcher, and, there's going to be hiccups there. You've seen the medical examiner recently. If they come right out of the gate with the ARCA guys who are very credentialed experts, very professional, and they, I'm paraphrasing, but they basically come out and say, look, in our opinion, to a reasonable degree of scientific certainty, and we have all the right degrees and all the whatever, there's no car accident. And this, because the damage to the car doesn't fit and the damage to John O'Keefe doesn't fit. Never mind Brennan's cross of them. I don't think he's going to do what he did at the hearing. I think he's foolish if he does. These are real experts. You're better off attacking them on the science rather than their bias. That's stupid. But anyway, assuming they leave the stand and the jury is of the view, wow, they really have some pretty compelling evidence that this may not have been a car accident. That leads to the obvious inference where the taillight pieces come from. They already know Proctor probably diddled with the glass, okay? They know the taillight pieces were recovered in a very bizarre way over the course of 3 weeks. So after the ARCA people, I'm calling Proctor, okay? And Proctor, of course, is the boogeyman. It's already looking bad. But all of a sudden, you have bolstered your examination of Proctor because the scientists have essentially told you that taillight didn't get there from a car accident. Here comes the guy who probably, the defense argument would be, is the, agent provocateur of the taillight if he wasn't the guy who literally sprinkled it. And I would call him and clobber him. There's nothing he can do to hurt your case. Then I would move into the Higginses of the world, because if the taillight is planted and there's something going on, now you're getting into all the weird stuff, the text messages, the butt dials, the dispute at the bar. This all, one thing flows from one to the next. And then I would finish up with the dog people, because they're going to be credible experts too. And have, you have all this weirdness going on. And here come two experts who are going to say, you know what? That's not from a car. That's from a dog. So I would flip this on its head, do the ARCA first, the same way I've always said they should have done the summation in the first trial. Start with ARCA. It all flows from that. But I think you get the jury immediately on your side, and it looks that much more dastardly for Proctor, Higgins, and all those people. And then you finish up with your ME, your other. So you still have science at the end, and you smother them. I mean, you're putting on at that point, I think, a very, very compelling case.
And then Brennan will recall we'll call Crosby or Terry Kuhn for the rebuttal.
A dog trainer. I mean,
right,
okay.
A dog trainer, exactly.
Dr. Russell, by the way, Dr. Russell, if you recall, I guess you can thank Brennan for this too, because he wanted a grill her to voir dire. He's getting 2 for 1. Don't forget, not only did she write the proverbial book on dog bites, but she was in the ER and pathology and all this other stuff for years. So she's actually allowed to talk about car accident injuries, dog bite injuries, and all that, and give an opinion that doesn't look like a car accident. So you do her last or close to last, you're getting 2 for 1 with her.
Yeah. Can't say I disagree with you. Jen Helmish-Sackett, thoughts on defense possibly calling Mr. Reed as a witness to discuss him seeing taillight before towed, and followed up with Barrows to corroborate the state of the taillight. Risky but rewarding. What's your thoughts about that?
They could do it. I don't know if they would or they will. There's been a suggestion from Mrs. O'Keefe and Brennan, without any evidence, I might add, that, Karen went upstairs and in the presence of her father was, yanking wires and taking hammers to ring servers and all kinds of things. And then they, took the murder weapon back to the house where they put it in the driveway where the taillight was on open display for all to see, which sounds a little weird to me by arguing that that's consciousness of guilt. But so the defense could do that. It also is a way to get out there some very great sympathy to Karen without her testifying, because if you know Bill Reed, he's one of the nicest people you'll ever meet in your life. I mean, he's that nice, he's that good. He's a religious man. He's honest. It's not surprising, let's put it this way, that the defense, despite all the oh, we're going to call him and subpoena all of his stuff. There's no way they would call the family members. That would be far too risky. But I don't know if the defense would, but it's something I would give serious thought to.
Yeah, it's funny. Brennan did play with that idea. I mean, he was mentioning it before trial that maybe he's going to call the mother or father because Karen Reed called him that night, but he didn't end up calling them.
I think he did it to just needle them, intimidate, get scared. The same way he said he was going to call someone who we're not going to talk about right now. That was never going to happen. I think his pattern is just to use the witness list as a sword to try to, intimidate. I mean, I think that's what he's used to doing. But that's not what prosecutors are supposed to do.
Yeah. Here's a good question. No hoodie, Mark?
Some days, as we were talking earlier, some days you got to pay the bills. So you got to, I have to stay 2 steps ahead of my creditors. And contrary to what a lot of the people who love me online, I actually do work. I do have a practice. I do make money. I do have bills. And do things other than this, believe it or not.
Oh, come on. All the money that you're making on appearing on all these shows that we have backdoor deals. Come on, Mark.
Absolutely. I'm going to Bora Bora next week on the Super Chat train. Thank you. Thank you.
Jenna on point. Is it possible that Judge Cannone won't allow the defense to respond to Commonwealth's rebuttal to ARCA? So you remember that she is allowing Welcher to testify twice. Initially, and then once ARCA testifies, then Welcher will be able to rebut the ARCA experts. Now, she's not going to allow any more rebuttal after that, right?
Probably not. But I mean, look, if you're going to allow a rebuttal, it's similar to thinking like redirect and recross, and it gets narrowed down each time. To me, if you're going to be fair, if Welcher were to bring up something new on his rebuttal, I mean, yeah, they're going to cross him, so I guess it won't matter. But fundamental fairness would seem to dictate that if the ARCA people are of the opinion that Welcher then missed something on his rebuttal, it ought to be allowed. You don't usually see this, obviously, but I wouldn't be restricting anyone in advance on what they can do if there's a legal basis to do it. I don't know why she does that.
Another question for you, Cat B. Will these sidebars ever be unsealed? I'm intrigued to see Brennan's flailing at sidebar.
They will, unless there's, certain topics about, witness safety or whatever. But at some point they will, and certainly the parties will have access to them. Obviously if she was convicted, I mean, she would need all that for the record on appeal and all of that. But yeah, no, they'll at some point, most of it will come out unless there are reasons that are not common to keep certain things sealed.
Right.
There's no reason for her to be doing 90% of the sausage making at the bench. I mean, it's a public trial. It's a matter of great public interest. There could be reasons. I get every trial. There's always sidebars. You always ask to approach and whatever. But I don't understand why every objection, everything is done at the bench. I just couldn't disagree with that more. It's a terrible look. It's a public trial. Unless there's a reason that the public shouldn't know, it's supposed to be an open courtroom.
Yeah. Although I did catch sometimes a grounds for an objection did escape one of the attorney's mouths. So
Brennan, yeah, every now and then. But I mean, again, I don't fault him for that because that's normally how it's done. I mean, I think that's just muscle memory. I mean, that's
how it's supposed to be done. Can you ask a witness, example, an ATF agent, how many times probably he has testified in court, and then how many times he has brought an attorney to court to advise him while he is on the stand?
Well, the simple answer is you can ask whatever you want, and she'll issue a ruling, and they've already heard it. So who knows? I mean, if Higgins were to bring his lawyer like he did last time, that is a disaster for Brennan in light of everything going on here. That would just be a terrible look that you get called by the defense and you bring a lawyer. Yeah, I mean, why not? Sure, you could ask him. This judge is very unpredictable in her rulings. My gut tells me that she would sustain that, although I can't tell you really why she should, but I think she would.
Although he may answer like something that I've spoken about on this channel before is that if you're guilty, you need a lawyer. If you're innocent, you definitely need a lawyer. So he may say, Well, the reason why I have a lawyer is because I follow all my advice that I hear from Brother Counsel that if you're innocent, you definitely need a lawyer.
I
So,
say all the time, I would never fault anyone for getting a lawyer. It's fine. The problem for the DA in this particular case is that Higgins needs to be squeaky clean. There are some issues with him. And if it turns out that within 3 days of the incident, he's the only one who brought a lawyer, he never responded to that text message from Karen, John died. And the next thing you know, he's going to his FBI friend. He's learning how to extract his phone. He gives them a very select set of text messages. He smashes his phone, then gets interviewed
and the
by
SIM card.
and his SIM card just to make sure, and then gets interviewed in the presence of his lawyer. It's not a good look. I mean, again, I don't blame him for getting a lawyer, but it's not a good look.
Oh. KCL, when do jurors typically make up their mind on whether guilty or not guilty in your experience? When I was a juror, I made my decision about 2/3 of the way through. We were unanimous with the defense. Well, I'll tell you in my cases when they make their decision, and that's usually once I finish my opening statement.
Of course. In a perfect world, that's funny and true. All kidding aside, lawyers like to joke like that. In a perfect world, it's at the end of jury selection, because you may have heard me say this. The theory of jury selection that I was always raised on was two things: get rid of the kooks and brainwash. And if you can brainwash and you have them with you, and that includes the weaknesses. A perfect example is, if I were the prosecutor in this case, I never would be, because I would never prosecute this case. But I would be voir diring.
Even if you would get paid 250 grand?
No, there's other ways to get 250 grand than that.
Right, super chats.
Exactly. See, he's quick. I would be voir diring on Proctor. Now, ideally, you would be doing like a real panel jury selection, not this one on a bench thing. But
ridiculous,
absolutely ridiculous. But you would be, you would be saying, on police, and you're going to hear allegations of, bad police conduct and this, but if I were able to do this and that, can you be fair? You start brainwashing. You're telling them right then and there, I have police problems, and are these people with me or not? Who knows? You want to see all that, but the real answer is you don't know. And if they're following the instructions, which who knows, the judge will tell them to keep an open mind and not think about those kinds of issues until they go to deliberate. But in the real world, yeah, people, but I don't know how far. I think each person's different.
Yep. Pro Gamer, can you ask Mark? Well, I'm about to ask him. What happened with Tom CPU and the buffer zone police and the federal appeal?
I have no idea. In full candor, I'm aware of like buffer zone shenanigans and like cops arresting people or violating First Amendment rights and this and that. So I've heard about all that. I know Randazza has all kinds of lawsuits going back and forth, and there's been rulings, but I haven't followed it that closely. So I'm ashamed to say I don't know.
Okay, well, guess what? When you don't know, the best answer is you don't know.
You don't know. I'm not that ashamed, but I don't know.
That's what we tell our witnesses also. Okay, here's another question I knew was going to come up. Jen, on pointing question, what do you both think about Canoni's recent Person of the Year award, and the event was sponsored by Aperture?
So I think, first of all, and this is important, I don't think that's accurate, okay? My understanding is that Aperture sponsored a Massachusetts Bar Association event, and Canoni was given an award by the Norfolk County Bar Association. That's two different groups. So the Norfolk County is just lawyers in that, that county, where Massachusetts is the whole thing. So I think it's very important to be accurate in what we're seeing here. So two different issues. Do you think Aperture sponsoring and buying and spending a lot of money on behalf of the Massachusetts State Bar while this trial is pending and while they are a witness, it's probably not a great look, but it's also how business works, where, they're getting exposure, they're putting a foothold in Massachusetts. I understand they're a Massachusetts person, as a former lieutenant in the Massachusetts State Police. Frankly, it's probably how they got retained on this case, to be honest with you. That's how business works as well. I think that's a very bad look, given that the case is on trial and whatever. But I don't think it's that. I mean, what are you going to do?
I mean, it could be they already, this was already in the works for months.
Absolutely. I think you have to be real careful to see goblins in every window. With Cannoni getting an award from the Norfolk County Bar Association, my reaction to that was, duh. I mean, what? I mean, Norfolk County strikes me, perhaps other lawyers too, as a very insular legal community that doesn't like outsiders, given her affinity for Alan Jackson and maybe others who knows. But
I mean, others who she did not allow to practice in front of her.
Yes, sleazy New York lawyers with alleged conflicts, which is not true, but
who pretend to be Celtics fans,
right? And who are accused by the prosecutor of passing information from one to another. You should know better, Mr. Brennan. That don't make statements you can't back up because it's not true and you know it. Anyway, putting that aside, it's a very insular legal community. She's one of their own. The place is being laughed at on a national level as some kind of county that you might expect to see in Alabama in 1944 kind of thing. So would it surprise me that they would honor a judge who's dealing with a difficult case and, defending, if you will, the legal community from all these attacks? I don't read into it. I say that would shock me if she didn't get it. That she's been there for a long time. She's been a judge in that county for, I think, a long time. I think the local community likes her. Whatever. She's made some questionable things in this case, but I don't think they particularly care what we as, outsiders think. I mean, I think that's, as she said to David, you know how we do it here. I make the Chinatown jokes. Forget it, Jake. It's Chinatown. I think that's what Norfolk County is. So, but it's very important to be accurate that the Judge Cannoni's award from the Norfolk Bar Association has absolutely nothing or no relationship with Aperture sponsoring a table at a Massachusetts State Bar event. It's not that.
Next question from Kelly. If Chloe bit, you must acquit. Why won't the Commonwealth test any of the third parties' DNA against what was found on his clothing? If it could clear them and it's already in their possession, why isn't J.O.'s family screaming about this?
That's easy because this came out in the first trial and it may have come out in the second trial, but I don't remember the DNA testimony in this case. It was very in the background doing other things. They didn't have a large enough sample to test. I mean, if you recall, my recollection from the first trial is very specific that they had an insufficient sample of the other male DNA to the point where they couldn't even test it. So there's no conspiracy there either. If you can't compare it to anything, the courts are not going to allow you to go take genetic material, which people have a strong privacy interest in, to compare to nothing. And there's the risk that it could be improperly compared to other things, that they have a right for that not to happen. But if you can't even compare it to the sample in this case, then in essence, there's no reason to take their DNA.
Here's a question that I keep getting. We'll see what you have to say about it. Do you think Brennan is trying to throw the case?
No. What I see, I've heard people say this. I don't understand that. He, in my view, will engage in any kind of tactic that he thinks help him, no matter how above board or underhanded it appears to people like us. I mean, he literally in the middle of trial changed his theory on the time of the accident after witnesses had already testified and the defense had cross-examined on a theory that was favoring them. He tried to pierce attorney-client privilege. I think he's made some questionable decisions that I don't agree with, but I don't think he's trying to tank it. I think he's very much trying to win it.
Yeah, I mean, especially how much he's been trying to keep Arca out of the case from day one. If you want to throw the case, let Arca testify, and you just do your thing. But I think he's trying too. It's just certain things like these strategy decisions about not calling Proctor. To me, they seem so elementary, which is why I think people start asking these types of questions. Where if this is a special prosecutor who knows what he's doing in a courtroom, and this is what all the lawyers out there are looking at this and saying, "You're making such an obvious mistake," what's he actually doing? So
look, I think maybe there's some buyer's remorse. Yes, he gets himself a fee. Yes, I'm the prosecutor on like the biggest case going on right now. That's all exciting, I suppose, although that's weird when you've been in private practice for 20 years, but whatever. But the reality is he made the decision, and he made his bed, and he's going to have to lie down in it and see it through. He knew Proctor was a disaster before it started. He knew what ARCA was. He knew what all these other problems with the case, and he dove right in. So I think he's trying to get through it the best way he sees fit. He may not be calling Proctor because it's conceivable. I'm not saying this is likely. You sit down with Proctor, assuming he's willing to sit down with you. The first thing you'd want to do is feel him out. Like, where's your head at with this? Like, because you don't want him to sandbag you on the stand. And he's too far deep, Proctor, that is. He's not going to turn or anything like that. But what if Proctor has a different view about what they said about him when they threw him under the bus in the pretrial hearings and blamed him for the video being stuffed in his back pocket for 2 years, not telling anyone? He says, that's not true, and you know it. Guess what? They're not calling him. It's over. So, maybe there's something else going on.
Then you lose it that way. It's like, like when you have a full, it's like when you have a full house and you go all in, you get beat. Well, you made the right call, So here's like, if he's going to get on the stand and destroy your case, well, what's the alternative? Not call him and let Alan Jackson call him? Like, is that really like that's how you're going to win this case?
His biggest asset to winning the case would be his own credibility to tell the jury we're going to get there. There's a lot. It's a rocky road. There's a lot of, it's a minefield, and we have to tap dance around all these mines, Proctor, Google searches, all this. But at the end of the day, trust me, we have science. I'm going to get you there. And he has given that up. He has come off as somebody that the jury's going to say, you're sleazy. I don't like you. I don't trust you. You're hiding things from me. And you're supposed to not do that. And you're making the defense lawyers the good guy. And why he did that, for the life of me, I can't understand.
Yeah. Let me ask you a question that I've gotten a few times. And that is, let's say this results in another mistrial. Do you think that they try for Karen Reed 3.0?
So I think there's a few variables you have to factor in there. I think to the extent you can learn, the breakdown would factor in. If it's 11-1 to acquit on all three counts, even someone like Morrissey has to do, if assuming it's him, has to do some deep thinking there. Okay. For all intents and purposes, she got acquitted on 2 counts the first time, not in a legal sense, but in a practical sense. It's obvious the jury had no use for 2 of the 3. Now, it's true, the prosecution was ahead on the hung count, the true hung count. But I think that's a factor. Another factor is Morrissey under siege? Is he still DA? Depending on the timing of all this and an upcoming election, people running against him. A new DA, I think the answer would be, we're not doing it. The other issue is citizens of Norfolk County and taxpayer revolt. Perhaps the most offensive thing about this case is not only are you doing it twice, and you're doing it, on some level, not as good as the first time, as hard as that's to believe. You're making us pay an extra $250,000 for Brennan. You're making us pay God knows how much for this Aperture stuff. You're making us pay for all these experts we didn't pay for. And as a taxpayer, I've had enough. This is not working. It's not right. So that's something that would factor in. And I think also, I'm not saying this would be successful, but, the defense could at least try after 2 to argue double jeopardy, that there shouldn't be a third one. I don't think that would necessarily win yet. there does come a point that litigation must end. But I think the DA, if you said right now, their position would be yes. But the other thing you have to factor in is how damaged are they by the case? I mean, is Jennifer McCabe going to do this a third time and come up with a third story? Proctor's pretty much gone for all time, right? If Welcher gets destroyed, the timeline's moved already. Burgess is out at another trial, obviously. At what point do you say, there's no there? Like, what do I play with? What's my presentation? So I think it's trickier than just saying, we'll do it again. The other thing I think you would see happen if there was a third trial, I think you would see the defense move for another judge on the theory of an appearance of a bias. Because that argument is a lot stronger now than it was right after the first trial. I think
you know who decides that, Mark.
Well, it is her. It is her. But depending on what she says, and you're building a record, the problem is, I think she way overreacted on the ARCA discovery issue and her statements about the defense attorneys vis-a-vis whatever Brennan does with discovery and the Sally Port video and all of that. The expert witnesses. I don't think any lawyer could ever justify why we had so much pretrial, gatekeeper type hearings about defense experts, but virtually none for the prosecution, not granting a hearing on the motion to dismiss. You don't have to say she's biased. You say there's an appearance of bias and let her say no. Maybe she doesn't want to deal with it again. I don't know. But
and most importantly, not allowing this slick lawyer from New York to join the firm.
Well, obviously, that would be number one, of course.
All right. Well, Mark, it's been great talking with you and taking some of these questions. I know everybody enjoyed it. I know I enjoyed it. Last time. Yeah, we're going to have to continue doing this, whether it's on this case or another case. But appreciate you coming on. And, there's always next year for the Celtics. So we'll root for that.
Not next year, the year after. Next year is, yeah.
Oh,
no
okay.
Tatum, no bueno. No.
Okay, fine. All right. All right. Well, thank you very much, Mark. Appreciate it. And we'll see you next time.
Okay. Take care.
Okay. All right. Well, that is it. That's Mark. It was great to have him on and discuss this case, all about some of my questions, some of your questions. And hopefully that'll feed some of your addiction needs on the Karen Reed case and the withdrawal that we're all having now because of the last few days not being able to watch the trial. And the next next day is going to be Tuesday, which of course we will be live streaming right here at Brother Counsel Studios. But we still have an exciting weekend ahead of us for you guys here. On Sunday, I'm going to be joined by national trial attorney Solomon Radner, Brother Counsel's Brother Counsel, to recap the past week and some other things that's going on in the Karen Reed case. I'm sure you're all going to be dying to hear some of his blunt takes. He speaks his mind, and he knows his way around a courtroom very well, so he'll be able to tell you about some of the cross-examination that we've seen. So we're going to have that on Sunday, and we'll see. We're working on something from Monday too, but we got to keep feeding that addiction that we all have right now. So thank you all again for joining us. Thank you for respecting the no super chats. Still appreciate you all coming in and listening to Mark, listening to myself. And if you haven't yet, please subscribe, like this video. You can check out we have on the podcast now, Apple Podcasts, Spotify, where you get your podcasts. You can find Brother Counsel there if you prefer to listen instead of watch. So that's going to be it for now. I hope everybody has a great weekend, and we'll see you all here Sunday, 11 a.m. Eastern, when I'm going to be joined by my brother, Solomon Radner. Have a great weekend, everybody.